We have just formed the quorum, and this is the Bills Committee on Employment Amendment Bill 2014. This is the third meeting. I call this meeting to order. Last Saturday morning, we heard the views of deputations, response from the administration. We've also started discussing the administration's first paper. We will continue with our discussion. I'm not intended to start the clause-by-clause scrutiny. Let's invite the administration in.
Hi. 各位午安。
Good afternoon. So we have representatives from the administration, which should be the same as those last Saturday. We have representatives from the Labour Department as well as the Department of Justice. Well, during the second meeting last Saturday, we discussed one of the papers, CB bracket 21294/1314 bracket 01. And today, we'll start by discussing a letter issued to the administration from the Assistant Legal Advisor, and the paper number is CB bracket 21294/1314 bracket 1. The administration's response is CB bracket 21480/1314 bracket 05. Now the administration can be brief in walking us through this paper, since some of the content is already covered in the legal advisor's letter. Now, it's a response to 3 points raised by the assistant legal advisor. First of all, the legal advisor asked about the birth of a child to an employee overseas and what documents should be provided. Our advice is that the father will be required to provide the birth certificate of the child born overseas, and if the child is born overseas, the employee should provide the birth certificate issued by the relevant authorities overseas. However, we've also considered that some of the jurisdictions may not issue birth certificates, and in that case, other documentation can be provided to prove the father-child relationship. Should there be any disputes, similar to other benefits under the Employment Ordinance, the Labour Tribunal or the MECAP can take up the case. The second issue is about the calculation of PL pay. And now the average daily wage is 4/5 of the wage payable is 4/5 of the average daily wage. And it means the daily average of the wages earned by the employee. And the average daily wage should only be interpreted in this manner and not other manners. So we find this suitable to be adopted. Now, the other issue is about the mode of taking paternity leave and that it should not be counted towards the leave in lieu of notice period required for the termination of contract. Now, a 7 days advance notice is required for the termination of a continuous contract. and the annual leave could be 7 to 14 days, and if the notice period includes the annual leave or the paternity leave, this will cause the termination to be made effectively, and thereby cancelling the effect of the notice period. So, even taking into account the 3 days paternity leave, the employer will not be able to terminate the contract once the PL expires, so we do not find it necessary to exclude the taking of PL during the notice period. Any questions from members? Mr. Chung Pok Pam, 4 minutes each. Mr. Felix Chung. Thank you, Chairman. Last Saturday, some colleagues asked 2 questions. First is on documentation overseas for proof. Some jurisdictions may not use English. For example, in Burma, in Thailand, they may not use English. So how can one provide documentary proof? And Mr. Hui from the Labour Department suggests that it will be left to the decision of the Labour Tribunal should there be any dispute. And the officers at the Labour Tribunal still won't be able to adjudicate on such disputes if no English certificates are provided. And second issue is that there may be persons of the same name in the other jurisdiction. So how can one prove one's identity? And Mr. Hui, first of all, should there be any disputes, the Labour Department will try to deal with the disputes by way of conciliation. We have experience in terms of various employment benefits. We have conciliation service, and we can take a pragmatic approach in resolving disputes. However, if the disputes cannot be resolved, and if the case is taken to the Labour Tribunal, the adjudicating officer will look at the evidence to prove the authenticity of the document, or to prove otherwise, or say how evidence of the child being the employee's a child, and it's up to the adjudicating officer to adjudicate on the disputes. Say, I don't understand, Chairman. I don't want to say something which may be offensive to the jurisdiction, but in some places you can buy documents, so to speak, and we cannot trace or certify the authenticity of the documents. So how does the Labour Department or Labour Tribunal strike a balance? Mr. Hui, we have considered this issue because we are talking about 3 days of paternity leave. If the employee is to proffer false instrument to cheat the 3 days of paternity leave, he will have to bear a very serious criminal legal consequence. And perhaps at the conciliation stage, we can offer help by verifying the truth of the document with the consular of the jurisdiction. If there are reasonable doubts. Any follow-up questions? Mr. Zhong, may I also respond to your point? I'm not speaking on behalf of the administration, but very often in another jurisdiction, if a document is written in, say, Russian or Thai, and if this is to be exercised in Hong Kong, we follow a set of procedures. Say, for a document in Thai, first of all, we would certify the document with the help of a certified translator of that jurisdiction. And then the notary public of that jurisdiction will further certify the document. Apart from such a certification process, some jurisdictions may also ask the consulate's office to do another stage of verification. So it's different jurisdictions have different arrangements, and there are established procedures for the document to be valid in Hong Kong. So, Mr. Zhong, you may refer to these procedures. And Mr. Hui, I recall at the last meeting you said if necessary a set of guidelines can be issued, because often the Labour Department issues guidelines in relation to birth certificates or documentary proof in another language. I think at an appropriate time, it would be conducive to have a set of guidelines. Mr. Tan Kah Pew. Now, members have raised this point before, and say I have indicated that my wife is pregnant and I am entitled to the paternity leave, and after I make such indication, the employer then dismissed me without grounds. And I see the Labour Department or the EOC also issued a letter. That's paper 1454/1314/06. And in the succinct letter from the chairman of the EOC, the nature of the paternity leave and the maternity leave is similar. That is to say, the employee will be protected in terms of their right to take paternity or maternity leave, and they will not be dismissed on this ground. And the business sector is of a view that they do not, they dislike the 3 days to paternity leave. They think one would rather change their gender in order to get the paternity leave. And it's agreed that there is no need to have any provision to protect such. And why hasn't this been done?
Perhaps I can state our position in response of the EOC's comment. The Labour Department is of the opinion that the requirements regarding paternity leave should be aligned with that of the maternity leave for reasonableness and consistency. In the electrical brief, we've already pointed out that the Labour Advisory Board agrees and is of the opinion that if it is appropriate, where it is appropriate, that is, the arrangements for paternity leave and that for maternity leave should be consistent as far as possible. So in considering the regulations regarding paternity leave, we'll first of all make reference of the arrangements for maternity leave, and see where it could be applied to the proposal in respect of paternity leave. First of all, we have to find out whether or not the circumstances are the same or similar. In many cases, they're similar. However, there are instances where they are not. For example, for maternity leave, it's 4 weeks prior and 6 weeks after delivery of the baby. And that would be, that cannot be arbitrarily changed. In the case of paternity leave, well, this is a family-friendly initiative. We've considered the need to look out, to take care of the needs of the father. as the government, as the employer, we don't know on which particular day the employee would like to take his leave because the situation of different people vary. So in designing the paternity leave, we say we'll not follow the same arrangement as in the case of maternity leave. Rather, we allow the employee, so long as he serves a prior notice, he can choose the day on which he'll take his paternity leave. So there are areas where paternity leave and maternity leave are different. And if the circumstances are not the same, we need to come up with different arrangements. Going back to employee protection. For maternity leave, the employee protection is not to ensure that the employer cannot dismiss the staff during the course of a pregnancy. This is not only to produce the employee so that she will not be dismissed because she takes a 10-week maternity leave. Well, this is a protection for the employee so that she will not be dismissed after delivery, because the women during the period of pregnancy may not undertake strenuous work, or I think we already have the and we have the law governing maternity leave in 1981. We didn't even have EOC at the time. At that time, for women to be dismissed during the course of a pregnancy, it was considered difficult for them to find an alternative job. So for women, we therefore believe that we need to give them the pregnancy protection. Director, there are 4 aspects of employee protection: prevention of women from being terminated during pregnancy. Now, it's not just about maternity leave. Since paternity leave and maternity leave are similar in nature, why don't you also incorporate it as well? But anyway, who's next? Ms. Sito. Of course, we're all for paternity leave, although we've not yet gone to the clause-by-clause scrutiny of the bill. But I'd like to take one aspect of the bill for discussion. That is, when should the employee notify the employer as to when he will take the leave? I don't know whether the law draftsman had experience of having a baby born in the family. I mean, you can never be 100% accurate about the date of birth. Even if you serve a prior notice to your employer, the doctor estimate may not be correct. So the idea of a paternity leave is to allow the husband to accompany the mother during those few days when the child is born, and you require the employee to serve a prior notice a few days earlier or 3 months earlier. That simply won't work. Why don't you allow for more flexibility? Eventually, you would still require them to provide the documents to support his claim. If everything would need to be arranged, or you allow them to take the leave 10 weeks after the birth of the baby, then it would not really be paternity leave at all. I think the purpose of the paternity leave is mainly to allow the employee to take care of the wife before and after the delivery of the child, as well as the newborn. It's not necessarily the case that the employee must spend the time keeping company with the wife during delivery. I think the arrangement now is aiming to strike a balance between the needs and interests of employer and employees. The LAB had discussed this issue thoroughly. Of course, on the one hand, we need to take care of the needs of the employee, but as employers, they all have their own working arrangements. There are certain work which cannot be put on hold just because an employee suddenly wants to take leave. So the 3-month prior notice, and when the employee serves the notice, doesn't need to tell the employer when specifically he will take his leave. All he has to do is to tell the employer that his wife is about to give birth to a child, and that would be sufficient. The employee may then require him to serve the notice in writing. Otherwise, a verbal notice would do. If he can confirm when he's going to do the paternity leave, he will still need to serve a 2-day notice beforehand. This will help balance the interests of both parties. That's why I don't know who is the person drafting this bill. If a woman were the law draftsman, I think she would definitely not draft in this manner. men never have the experience of giving birth, and I think giving birth to a child is not like setting an alarm clock. The most crucial period is not the 5 weeks after the baby is born, when the family is already used to the newborn child, but rather the few days prior to going to the delivery room, or if there are any complications, you need the next of kin to sign the agreement for medical procedures and so on. Have you really considered this? I'd like to ask whether or not the person who drafted this bill is a man or a woman. I think if a woman were the law draftsman, she would never have, drafted the bill in this manner. Mr. Hui. It really depends on whether or not the wife opts for, natural birth. So how can how would the employee be able to serve a 2-day notice? Well, that is what the bill proposes. But now, since we don't have paternity leave arrangement at the moment, we would encourage employer and employees to allow the employee to take his leave to deal with the birth of the newborn child. Even if we have the arrangement in place, I'm sure that having a newborn child is something to celebrate, and I don't think employer and employees' interests are in conflict here, because I'm sure many employers, even if the employer serve a notice that is shorter than 2 days, the law requires a 2-day prior notice. But if the employer thinks that if he knows that the employee needs to take his leave immediately, we will not stop the employer allowing the employee to serve a shorter notice to take his leave. Well, in that case, I think we should allow more flexibility in the bill. I think, Ms. So, you can later on submit an amendment. Mr. Kok Wai Keung, thank you. I have a question about the meaning of average daily wages. Previously, workers worked on a monthly wage. You would divide the monthly wage, divide that by 30 or 31 days, and that's how you work out the average daily wage. Now, ever since we have the statutory minimum wage provision, some employers, by making use of certain, loopholes in the law, will argue that the regular rest days will not be paid, or in some circumstances, employees will not be paid minimum wage during the rest days. I've dealt with such cases. Although the difference in the end may not be very large, but where there are disputes, the matter is taken to the Labour Tribunal, wasting a lot of time and effort. So I'd like to clarify once and for all how you work out the average daily wages. Are you only taking into consideration the typical working days, or also the rest days where the minimum wage does not apply? Ms. Loh. I think the drafting of this provision has already deleted those which have to be deleted. For example, the rest days where the employee is not earning normal wages. So during the whole period, there might be days where he had taken sick leave, where he is entitled to 80% of the daily wage and so on. All those will be taken out from the consideration. So the daily average wage is only refer to the actual number of days where the employee actually reports for work. Mr. Kwok, do you have other questions? I believe my other questions have been answered already. Legal advisor, regarding the average daily wage and also the daily average of the wages, I believe our legal advisor has some comment about that. In the government administration's response, the administration saying that in respect of other employee benefits like sick leave, annual leave, and how the method of calculating the daily wage is the same. But in the present amendment, you've used the term average daily wages. So I like, now, given that the law would need to be consistent, so if you have something with the same connotation, then the same terminology should be used. So will the Bureau consider using the terminology, name the daily average of the wages as it is used in other ordinances? Perhaps Mr. Lam from the DFJ could explain this point. Thank you. We believe that the wordings used for the maternity provision, I think the meaning is the same as the terminology used in the current bill. It's a matter of presentation. We're talking about the average daily wages or the daily average of the wages. We believe that the average daily wages is a more concise method of presenting, a more long-winded way of presenting the same concept. The term average daily wages is also terminology that is widely accepted in the community. So the daily average wage of the wages, we believe, is not different from average daily wages. So since it doesn't affect the clarity of the bill, we propose therefore to use a more concise way to present this concept. But in that case, shouldn't you replace the longer version of daily average of the wages in the Employment Ordinance to average daily wages? If not, I've already told Matthew Cheung that the Employment Ordinance has been amended numerous times since 1968. And the drafting style has been very confusing. If you intend to change the terminology here, would you consider whether or not you can change all the reference to daily average of the wages in the Employment Ordinance to average daily wages? Or are you going to confining it to the bill referring to paternity leave? Chairman, we believe that the term average daily wages is an improvement. If in other provisions of the ordinance, if the Bureau thinks that it's desirable to change that to average daily wages, we are happy to do that. It simply represents two different styles of drafting, and it's not necessary for all the provisions to use the same terminology. So we'll be happy to review the other provisions. May I propose that you talk to the Bureau to see whether or not there's a need to do that. For the users, this indeed will cause confusion. If within the same ordinance you have two different terminologies with the same meaning, I think in the original drafting instruction you are not asked to simplify the terminology. But I think you need to raise this with the Bureau and give us, an answer at the next meeting as whether or not you will do what I suggested earlier. Next, Mr. Lee Cheuk Yan.
Thank you, Chairman. Now, in the paper, it said there is an explanation about paternity leave pay in lieu of notice. I don't agree with the administration's explanation, which said that maternity leave and paternity leave is just paternity leave is just 3 days. It can't cover the whole of the 7 days minimum advance notice period. Now, annual leave days can be used in lieu of notice. Now, sometimes after 4 consecutive days of leave, then only 3 days are left, and this cannot be offset against the notice period. Similarly, here, it's 3 days, and some suggest the PL should be extended to 7 days. Then my suggestion is to make things clear. use the same approach for PL as well as annual leave. Paternity leave should not be used or included as leave in lieu of notice. Say, now I give you notice 7 days in advance, but after 3 days of paternity leave, only 4 days are left. So maybe you should make it clear that after you take the paternity leave, and only after you do so can you start the notice period. Now about PL pay, we ask for full pay instead of 4/5 average daily wages. Although I understand for maternity leave the pay is also 4/5. Now one of the justifications from the administration of setting the PL at 3 days is that if you accept the survey, which suggests the result of which suggests that the average is 3 days, you should also adopt the other finding. That is, most of the responding organizations would like to give full pay to the for PL, close to 90%, over 80% of them. So why don't you follow this part of the findings as well, Mr. Hui? First response, or responding to the first point, paternity leave and in lieu of notice. As explained just now, under the Employment Ordinance, there are other benefits. For example, for the first 3 days of the Chinese Lunar New Year, the employee is entitled to leave, and we have not included in the legislation that this cannot become part of the notice period. If within the notice period there are statutory holidays, we do allow them. So maternity leave and paternity leave are exceptions. Or maternity leave is exception because it's too long. For paternity leave, it's not very different from other statutory holidays, and that's why we do not include PL as part of the notice period. As for the survey, now the findings of the survey is that full PL pay should be given, and we only suggest 4/5 average daily wages because the arrangements are different. We refer to the survey because for paternity leave provided by these organizations, there are some characteristics not existed in Hong Kong, and we, based on the findings of the survey, suggest 3 days paternity leave as the starting point. Mr. Hui, I don't quite understand. Paternity leave in the notice period, how do they work? Just now, Mr. Lee mentioned the minimum advance notice period of 7 days. Now, let's say a notice is given to take a 3-day paternity leave, and then against the 7 days notice period, does it mean that the notice period can be shortened to 4 days? Chairman, yes. A simple example, say an employee will be taking PL soon. Right before he takes PL, the employer gives period 7 days in advance of his dismissal. If the PL cannot be taken within the notice period according to the law, then before the end of the notice period, the employee is not entitled to PL. After the notice period, he is not entitled to PL either, because he is only entitled to the PL if he is in still under a continuous contract. So if the PL period and the notice period overlaps, then after the employer gives notice, the employee can give notice to take PL within the 7-day notice period so that the employee's rights will not be deprived of. So shouldn't the logic simply be 7 days plus 3 days? If the 7 days is the notice period and the employee is entitled to payment of wages, whereas for PL, he's entitled to 4/5 average daily wages. Let's say if you take the PL first, say if you take the PL in April, you get 4/5 average daily wages for the 3 days, and then in May, the employer gives you a 7 days notice period, and you should be entitled to full pay for these 7 days. So shouldn't 3 plus 7 be a more logical explanation? If this is set off in such a manner, I really find it strange. Is it because employers think it's too costly, or is it really your policy that it has to be done this way, Mr. Hui? Well, this is not prejudicial or favorable to any party. Now, 7 days mid-notice period doesn't mean that you get payment of 7 days wages in lieu of the notice. Let's say if the employer wishes to terminate the contract of an employee, he has to give notice 7 days in advance. And the employee works for another 7 days, after which he will be given the pay. On the contrary, if the employee gives notice, it also works for 7 days, and he gets 7 days of pay until the end of the contract. If we stipulate in the law that within the notice period the employee cannot take PL, let's say if the employee hasn't taken the PL and then the employer indicates or gives notice, then the employee will not be entitled to PL within the 7 days notice period, and he has to work for the contract until it's terminated. On the contrary, after the employer has given notice, within the 7 days notice period, the employee can still indicate when, within the 7 days, he will take the 3 days of PL. Yes, although you've explained, I still don't find this rational. I am a professional. I also understand the interest of big corporations, but I still think the logic should be 3 plus 7. Any questions for the first round? Second round then. 4 minutes, Mr. Tan Ka-piu. Thank you, Chairman. To follow up on the point about unlawful dismissal and employees' protection, which I asked about just now, I don't understand why it doesn't cover PL. About if it's not covered under employment ordinance, you can enact another provision. It is just technical. If it is similar to PL, and protection against unlawful dismissal also covers injury at work, sick leave, so on and so forth, I don't see why you cannot do the same for PL. So please consider, is it the case that in no way you will do it? Let me respond first. Please respond to Mr. Tan Ka-piu's question. It's a very simple question, whether you can include this in the bill. Employee protection, but there are different purposes. The greatest protection is pregnancy. That is, once the employee gives notice that she's pregnant, basically the employer, for whatever reason, cannot dismiss the employee, even if the company is losing money. For whatever reason, the employer is not entitled to terminate the contract of the employee. So this is a major protection. For sick leave, the protection is that the employee will not be dismissed during the sick leave period. Now, for paternity leave, we look at whether there is whether the employee will be dismissed during the paternity leave period. We agree that it shouldn't be the case. After giving notice to the employer, his intention to take PL, it's not the case that the employer can, under no circumstances, dismiss the employee. According to the relevant ordinance, the employer cannot dismiss an employee based on the family role he plays. If the employer because the employee has to take paternity leave to take care of the newborn, and if the employer dismisses such an employee on this ground, our view is that it will be contrary to Family Status Discrimination Ordinance. That is the case of dismissal based on the ground of PL. Now, a more specific example, injury at work. If I'm dismissed whilst I'm on leave, of course the employer will not be so dumb. There may be various reasons, but no one will tell you expressly that it's because of your occupational injury. Now, we think that during the period, the employer should not, for any reason, dismiss the employee. The employer should be sympathetic. It should be overriding in nature. No employer would be stupid enough to tell you that it's because you should not have taken the leave. Well, perhaps the employee, after becoming a father, might be distracted from work. Mr. Hoyt, we believe that for a male employee taking PL, the situation is not the same as a female employee taking ML. We don't think the same level of protection should be offered. It's disproportionate.
So we've not added employee protection for male employees in the bill. Mr. Tung Kok Pan. I'd like to ask a question regarding the notice period. We heard just now that you can tell the employer 3 months in advance that you are planning to become a father, but you don't know the actual date of delivery. Once there is a confirmed date of birth, you need to provide supporting document before you can apply for PL. Before he obtains the supporting document, let's say he is dismissed, what is he going to do? He has not yet been able to serve the supporting document. So what should he do in this case? Well, the arrangement now is like this. If the employee wishes to take the PL, he only needs to serve a prior notice to the employer. That is 3 months beforehand, he will tell the employee that he is going to take the paternity leave. And on 2 days before he takes the actual leave, he will tell the employee which 3 days he's going to take the leave, and then he can take the leave accordingly. If the employer thinks that he's not satisfied with the verbal notice and require the employee to submit a written notification regarding where your child is going to be born and what is the expected date of delivery, the employer could demand the employee to provide such a statement before allowing him to take leave. Regarding other supporting documents like birth certificate, that will have to wait until the employee has taken his paternity leave before he submits such documents. And then the employer will, after receiving the document, pay him the wages for the PL. If the employee, during the course of his employment, has not been able to take his paternity leave, then after the employment relationship is terminated, then he will no longer be need to give the PL. Let's say before he is giving the supporting document to claim the wages for the paternity leave, and the employer dismisses him. So what's going to happen to this employee? Well, the law stipulates that if the employee has taken his paternity leave, he would need to submit the supporting document within 12 months, for example, the birth certificate, before the employer will pay him the paternity leave wages. But before he submits the document, if the employee is already dismissed by the employer, then the employee would need to, 6 months after his dismissal, submit the supporting document to the employer. Upon doing that, the employer will have to pay him the wages for the PL. Mr. Kwok Wai-keung. To follow up on the 3+7 proposal suggested by the chairman, I'm all in support of that. As someone from the trade union, I think there are some problems in relation to paternity leave. If the employee takes the paternity leave and afterwards only then will he serve the notice period, because all paid holidays cannot be offset. Any offsetting mechanism is depriving the original benefits of the employee. Whether it's sick leave, annual leave, or statutory holidays, for such paid holidays, they will not count as part of the notice period. Why is it that in the case of the PL you allow that? I think what you've told us just now is simply not logical. Or is it because the LAB asked you to do this, or do you think you should do this? Or were you under pressure to do this? I think this arrangement is not beneficial to either the employer or the employee. It would depend on the situation. If the employee wishes to leave early, after serving 7 days of notice, he takes the last 3 days as paternity leave, then he can leave 3 days earlier. And that arrangement does not just apply to PL. Other holidays, like statutory holidays, the first 3 days of the new year. If you tell your boss on the last day of the Chinese year that you're going to quit, then the first 3 days of the new year would also count. So whichever party served the notice, they will count as part of the notice period. So it's not that it can't be done. The only exception, as we said in the document, is the annual leave and maternity leave, which are longer. We do not, whether it's for the employer or the employee, it may not be beneficial. Mr. Hui, you told us that the employee originally should work during the notice period, but since he is on holiday, he doesn't need to work. But what about his wages? Would he get 100% or 80% of his wages for those 3 days? And if the employer doesn't give a notice at all and give him wages in lieu of notice, and who will stand to benefit? If the employee has taken his PL within the notice period, he will be paid for those days when he actually came for work. Let's say he worked for 4 days. For the remaining 3 days, since he did not report for duties because he took his PL, then according to the law, he will be paid 4/5 of his average daily wage entitlement. That is the arrangement for leave taken within the notice period. On the other hand, for both employer and employees, if there's no notice served and the employee is immediately dismissed, then the 7 day the employer will need to pay wages in lieu of the 7 day notice, and the 7 day wages will be the average daily wage. Well, in this case, the employee may not be able to take his PL. He will only be paid the wages in lieu of notice, and he is not paid the 3 days of paternity wages for the 3 days of PL. Is that the case, Mr. Hui? Well, according to the scenario described by Mr. Kwok, he's right. So we're talking about different arrangements may benefit some people and not others. Why did you allow him to take the PL first before you start counting the notice period? We're only talking about a difference of 3 days. Mr. Pan Siu Ping, 4 minutes. Thank you. Mr. Hui, when he responded to Mr. Tang's question about unreasonable dismissal, last Saturday, I also asked a question about the letter from the EOC. I think there's some problem with your response earlier. The view of the EOC is that the paternity leave should be aligned with the maternity leave. That is, the law should protect the employees so that they will not be dismissed because of the taking of the paternity leave. Of course, unreasonable dismissal includes industrial injury, sickness, paternity leave, participation in trade union activities, and serving as witnesses. So of course, if the employer doesn't allow the holiday, you can punish the employer. But the protection against unreasonable dismissal includes also the right to be reinstated and also claims for additional, payment and so on. I don't know if the LAB had discussed this and they want to align the two and ensure that the law is reasonable and consistent. Apparently, you're not being as consistent or reasonable here. So could you take a more detailed look at this? As the chairman said, if you add what the chairman suggested, it will make the bill more reasonable. Bearing in mind what has been pointed out by the legal director of the EOC. Well, Chairman, we have considered that a male employee is different from that of a female employee. When the LAB discussed the arrangements for PL, it stated in particular, and the EOC letter doesn't use these words, but in our letter to LegCo, we pointed out that the LAB pointed out that where it is appropriate for male employees taking PL, the arrangement should be as consistent with those of female employees taking the maternity leave. Actually, for PL and ML, the arrangement is not 100% consistent. Where we believe it is appropriate, we try to be as consistent as possible. But in some cases where we believe the circumstances differ, then we will not align them 100%. Mr. Pan. So for men to take paternity leave, and then if they're dismissed, they don't get the same protection as those for maternity leave. You get a big discrepancy here. Thank you. When the LAB discussed this issue, they noted that the paternity leave is only for 3 days. If the employer dismisses an employee just because it takes a 3 days leave, it's not very likely because we already have many holidays lasting for more than 3 days. For example, the beginning of Chinese New Year, we have 3 consecutive days of holidays. Over the years, we've not received many complaints that the employers would deliberately dismiss the worker immediately before a 3-day holiday. Of course, I'm grateful to members' comments, and we will, after the law has been implemented for a year, review the situation and see whether or not there are many instances where once the employee notify the employer that he's going to take his PL, the employer will dismiss him immediately. So we will we'll review the situation. Mr. Lam, previously, many people believe that we have very harmonious labor relation in Hong Kong. And employer and employees can sit down and discuss issues in a very calm manner without being subject to any external interference. I have 3 questions to ask. First of all, if you have an employee who applies for to take his PL, but no one can replace himself at work, his absence from work may result in the whole organization coming to a standstill. So how should we deal with this scenario? Must you allow him to take the PL? Is it really forbidden that the employer, will forbid him from taking the PL? Is there any mechanism that can satisfy the needs of both sides? Secondly, if several children were born, babies were born at the same time, how many days of PL will the employee be entitled to? and if on a particular day, at the same time, within a couple of 2 months, several female employees give birth to babies. So does it mean that you have employees taking 3 days, employees each time, totally 15 days? And what happens if you have people who donate the semen for women to how we cater to that situation? Well, the LAB had really discussed this issue. So in the design of the bill, we propose for a prior notice. First of all, 3 months prior notice. If the employee is aware that he's going to become a father, then 3 months before delivery, he was notify the employer about the approximate date of his child's birth, and that he would be taking his PL at around that time, so that the boss can come up with the rest arrangements. And then 2 days before he takes his leave, he will notify the employer which 3 specific days will he be taking his PL. He will need to serve a 2-day notice. So that balances the interests of the employers and employees. I think we need to cater to the needs of the employees. So, having considered this, we believe that the arrangement has balanced the interests of employers and employees. Secondly, an employee may have many women, giving birth to his children. According to the law, every time a child is born, he is entitled to 3 days of PL. That is the arrangement in the bill. But I believe that our birth rate in Hong Kong is so low, and we believe that for a male employee to have many women giving birth to his children at the same time is not very likely to happen. But anyway, 1 year after the enactment of the bill, we will review the situation. So you don't need to respect the system of monogamy in Hong Kong. Chairman. We've actually considered this as well. We've also sought legal advice, and we've also studied all the various anti-discrimination ordinance. We are of the opinion that the entitlement for PL is not confined to children born within wedlock. Our proposal does not require the employee to be the biological father before he's entitled to PL. The law stipulates that so long as his name appears on the birth certificate of a child in the column for father, so he's a father in a legal sense, and we're not a biological father. So a baby should only have one father who can take the paternity leave. Chairman, he's not answered my question. What about, someone who is inseminated through someone donating his sperms? And if someone donate a lot of his sperms, he could have a child born every day. Chairman, in the case of the employee donating his sperms, unless his name appears on the certificate of the child born with the help of his sperm, otherwise he will not be entitled to his paternity leave. If he donates his sperm to a woman, then apparently the woman who gave birth to the child, I think the name would be someone else whose name will appear on the birth certificate of the child. I think if you donate your sperms, your identity will not be revealed. So you've not done donated sperms before, perhaps I can help enlighten you there.
Thank you, Chairman, for sharing with us your experience. Oh, you're welcome. Any other questions from members on the policy? We have a paper, CB-21454/1314-06, which is a letter from the EOC, and Mr. Poon Siu Ping, along with other members, also raised points about this paper. We discussed it. So Any other questions on the policy? Mr. Lee Chuk-yan, 3 minutes. First of all, I request the administration to reconsider the 3-day, the notice period and paternity leave. And 3+7 should be adopted. If you really take a neutral position, then a clearer way is to have 3+7. Please go back, and I look forward to your positive response. Now, another question on the policy, on the question of dismissal, protection against dismissal after giving a 3-month, or rather, after giving notice 3 months in advance of his wish to take paternity leave. If the employee is dismissed within the 3 months mentioned, I'm not talking about lawful or unlawful dismissal. That's another question. Whether the employee will still be entitled to wages equivalent to 3 days of paternity leave, because originally the employee is entitled to 3 days of PL. Mr. Hui. Now, even if the PL cannot be taken during the notice period, it will not become 7 days plus 3 days. That is to say, the employer may give notice 7 days in advance, but the employee still will not be entitled to the 3 days PL. Now, about the scenario of employee giving notice of the 3 days of PL, and during the 3-month period, before he takes a PL, he gets dismissed. What should happen? Let's say for statutory holiday, which the employee is entitled, say Chinese New Year holiday, if the employee is dismissed before the Chinese Lunar New Year, the employee is not required under the law to pay the wages equivalent to 3 days of statutory holiday to the employee. But if PL is counted as annual leave, then the employer will still be required to pay for the annual leave. I don't understand why you always treat PL as a statutory holiday. This is not the case. This is a new category of leave. Why must you pack this to statutory holiday instead of annual leave, Mr. Hui? Our consideration is the length of leave. Paternity leave only lasts for 3 days. It's different from a 10-week maternity leave. We should compare it to leave periods of similar length, say statutory holidays. Even for annual leave, it's not very long. Let's say 7 days of annual leave entitled, sometimes only 3 or 4 days are left. So it's not very different. Annual leave ranges from 7 days to 14 days, depending on the individual employees. And we have not distinguished the minimum number of days. So all in all, since annual leave entitlement could range from 7 to 14 days, we don't compare PL to annual leave. Well, anyway, having heard everything, I still don't quite understand your logic, and there are still questions from members. I hope you go back and consider issues concerning notice period, etc. Any other questions? Ms. Chen Yunhan, 4 minutes. My question is similar to that raised by deputations last Saturday. Mr. Hui, you answered my question. You are under LWB, about 4/5 average daily wages. Some get full pay, some only get 4/5, and you quoted other jurisdictions. I don't agree. But sometimes we follow the practices in other jurisdictions, sometimes we don't. This is unprecedented. This is what the labor sector is has been striving for. Please go back and consider the policy, Mr. Hui. Thank you, Chairman. We have considered thoroughly, and this is also a consensus reached for the LAB. 4/5 average daily wages for PL. It's the LAB has thoroughly considered this point. When there were 3 meetings in 2012 on paternity leave, and towards the end of 2012, in November, I suppose, the consensus reached was 3 days of paternity leave and the average daily wages, and the wage being 4/5 average daily wages. Can you tell us more apart from the consensus? There must be differing views. Maybe eventually someone accepted or made compromises. I'd like to know the deliberation process. Well, it's not for me to talk in detail about the LAB's deliberation process. Of course, different members of LAB may have different views on paternity leave, but ultimately the consensus was 4/5 average daily wages. Now, Mr. Hui, very often the employees and employers have different views on labor issues. You need to look at the demands of the labor sector. Just like last time, the SLS, the Supplementary Labor Scheme, some say that the LAB agreed, but in fact the representatives of the labor sector did not. So please, it's not something new. 4/5 or full pay, we've been discussing it for a long time, and you're still so conservative. You haven't answered my question. Anything to supplement? Thank you, Chairman. Nothing to supplement. I emphasize that there is a consensus among LAB members. I will save the speech about a consensus. The labor sector asked representatives of a labor sector whether it was the case, and we felt wronged. The other question is originally the proposal was 5 days with full pay, now is 3 days, 4/5 average daily wages. The government also intended to take the most reasonable proposal. Now, do you think from the government's perspective that this is the most reasonable one for civil service? For the PL applicable to civil servants, the CSB assessed the government's position, the establishment and financial position before coming up with this employee's benefit. So you're saying that it's not reasonable? Chairman, please allow me to say a few more words. Well, yesterday I met with the representatives from a large catering group. They told me that it's in the catering industry, in fact. They told me that long ago they have already started giving employees 5 days of paternity leave. Why is it that when it comes to labor laws, we come to this situation? Anything to supplement, Mr. Hui? Nothing to supplement. If there are no more questions from members, I don't intend to start clause-by-clause scrutiny today, because the Labour Department still has to give us written replies to a number of questions. Date of the next meeting, I have a number of options. The 26th of May, Monday, 4:30. We hope that other policy issues can be clarified that day so that we can start clause-by-clause scrutiny. Even if we start clause-by-clause scrutiny by then, members can still ask details concerning the policy or concerning details in the bill. So the date of the next meeting is 26th of May, Monday, 4:30 p.m. Yes, Ms. Sit-Ho, would the administration go back and consider the point about the notice period? ask your female colleagues in your bureau. Yes, consider all the issues raised and give us a more comprehensive set of reply. Thank you.